Hello and welcome back to the Lawyer Talk, the podcast channel of BLawyers Vietnam. My name is Huynh Kim Thanh, and with me today is Miss Thi Thanh Ha. We are happy to have you with us again for today's episode. In this episode, we will be talking about the Law on Personal Data Protection 2025, also called PDPL, a new law that was officially passed on 26 June 2025 and will come into effect on 1st of January 2026. Recently, on 29 November of 2025, the government also issued the decision number 2623 approving the implementation plan for this law. Therefore, in this episode, we will raise 3 questions. For each question, we will look at it from 2 perspectives. The first is what the law provides, and the second is what is happening in practice so that you can better prepare before this law comes into effect.
Hello everyone, my name is Ha, and the first question that I think everyone should pay attention to is the first, what is personal data and how many main subjects are regulated under law? Under PDPL, the concept of personal data is provided in Clause 1, Article 2 of this law. To put it simply, personal data is divided into 2 categories, basic personal data and sensitive personal data. These 2 categories are stimulated, respectively in Clause 2 and Clause 3 of Article 2 of the PDPL, and will be further specified in detail according to lists to be issued by the government in the future. At this stage, we can generally understand them as follows. Basic personal data refer to personal data reflecting common personal identity and background information, which is frequently used in transactions and social relationships. And second, sensitive personal data refer to personal data closely related to an individual's privacy and when infringed, may directly affect the lawful rights and interests of agency, organization, and individual. In addition, the PDPL also regulates subjects involved in the processing of personal data, consisting of 4 main subjects, which are first, personal data controller. This is the party that decides the purpose and means of processing personal data, and in practice, this role is usually authorized. Second, personal data processor. This is the party that carries out the processing of personal data at the request of or under contract with the personal data controller. Third, personal data controller and processor. This is the party that combines 2 roles mentioned above. And the fourth, the third party. This is the party other than the 3 subjects mentioned above, which also participate in the processing of personal data.
In practice, we often see a very common issue, and that is when many enterprises are not fully aware of which role they are playing under the PDPL. A lot of businesses believe that if the data is stored on another party's system, then that party should be responsible for it. To give a specific example, a school may manage their student information by hiring a third party to provide a CRM. This is Customer Relationship Management System. This is a common system used to store information such as students or parent phone number, home address, or details about class and student levels. In this situation, business or organization often assume that the responsibility for personal data protection has been transferred to the service provider. However, when this is reviewed under the PDPL, if the business still decide what the data is collected for and how it is used, then from a legal perspective, that business is still considered a personal data controller and remain legally responsible for that personal data.
The second question is, what should business pay attention to when collecting personal data? Under PDPL, When collecting personal data, the first and more important point that business need to pay attention to is compliance with the sixth principle of personal data protection, as stimulated in Article 3 of the PDPL. Among the six principles, there are two important principles that you should pay attention to when collecting personal data. They are, first, personal data may only collected and processed within a project scope and for specific and clear purpose, and such collection and processing must comply with applicable law. And second, business must ensure the accuracy of personal data, and such data must be corrected, updated, and supplemented when necessary. Personal data should also be stored only for a period applicable to the purpose of processing. For example, in the cases where the top applicant is not recruited or an employment contract with an employee is terminated, the employer is required to delete or destroy the personal data of that applicant or employee, unless otherwise provided by law. In addition to complying with the POL principle, personal data may only be collected with the consent of the data subject, unless otherwise provided by law. Accordingly, the consent of data subject is specifically regulated in Article 9 of the PDPL, which can be summarized as follows. First, the consent of the data subject is only valid when it is given voluntarily and based on data subject being fully informed of the following information: the type of personal data being processed, the purpose of processing, who the personal data controller or the personal data controller and processor is, and the right and obligation of data subject. Second, consent must be expressed in a clear and specific way, meaning that the consent must be given in a writing form that can be verified. Third, consent must comply with the principle set out under PDPL. For example, consent must be given separately for its processing purpose. The content of consent must not be tied to mandatory conditions requiring agreement to other purposes beyond the agreed scope, and silent or non-response of the data subject must not be considered as a consent, etc. From this, the draft of the notice and the request for consent from data subject play a very important role for businesses.
From a practical perspective, we have observed that legal risks related to personal data often arise at the very first stage of data collection. A fairly common situation is that businesses collect a large amount of personal data without clearly identifying what that data is actually necessary for, and without distinguishing which data needs to be collected and which data is unnecessary. This, in effect, indirectly violates the principles of personal data protection. With regard to obtaining the consents of data subjects, in practice, this is often carried out in a very formalistic manner, such as first is combining multiple different data processing purposes into a single consent notice, making the content lengthy and unfocused, or using very long, general, and difficult to understand wording, causing the data subject to give their consent without actually reading the content. As a result, when a dispute arises or when competent authority conduct an inspection, businesses may face difficulties in explaining and proving that the consent were given voluntarily and with sufficient understanding, and the collection of personal data did not go beyond the stated purpose of the business. Therefore, the drafting of consent-related content, as well as the establishment of a proper consent process, is a very important part of the overall personal data processing framework.
The third question is, what should business pay attention to while transferring personal data across borders? In the current business climate, the cross-border transfer of personal data is a very common activity, specifically for businesses that are foreign invested interests. Under PDPL, the transfer of personal data across borders is not prohibited. However, businesses are required to fulfill certain obligations toward the Vietnamese state authority, specifically pursuant to the Article 20 and 21 of the PDPL. When transferring personal data across borders, businesses are required to carry out an impact assessment for cross-border personal data transfer and complete this assessment within 60 days from the date of the first cross-border transfer of personal data. Accordingly, businesses are required to strictly comply with this procedure. Of course, not all cross-border transfer of personal data are subject to this obligation. Under PDPL, the following cases are not required to carry out such assessment, including cross-border transfer of personal data carried out by the competent state authority. In case where an agency or organization store the personal data of its employee on cloud computing services, and in case where the data subject personally transfer his or her own personal data across borders, and other case as required by the government.
Thank you, Ha. And that brings us to the end of today's podcast. If you find this topic useful or if you have any question or concerns, please feel free to leave a comment below so that we can support you. For more information about BLawyers Vietnam, we invite you to visit our website, which is shown below the Lawyer Talk podcast screen. Thank you for listening and see you next time.